Right of first refusal. What is it? Who does it apply to? I'm Jacqueline Robertson with JR Law Group, and welcome to Family Law Friday. For any of you who have children who are facing divorce, or even for some of you who are already divorced and have a final decree, you likely have heard of or understand this term, right of first refusal. Right of first refusal is a term that applies to a portion of the Utah Code that basically states that parental care is presumptively better than surrogate care. And that means that if one of the parents, one of you or your co-parent, you have the children, this is on your regular parent time, and you need to be away to work, or you for some other reason need a babysitter. And the idea of right of first refusal means that you will offer that parent time to the other parent because, again, it's presumptively better that the child be with one of their parents. And also, there's no cost in that child care arrangement. However, the code itself, while it outlines that general premise, it's very general. And so it doesn't define, okay, if you're going to be gone for how long. It doesn't define what if you're remarried and the step-parent's around to watch the child, is that okay? There's no specificity about any of these scenarios within the code. So first of all, let me say right of first refusal can just be a confusing cluster that makes sometimes already high conflict or difficult situations more difficult, giving the parties something to argue about with there being no clear direction. So on that basic premise, a lot of times I opt to not have right of first refusal specifically outlined in a divorce decree. Of course, it's up to the parties, but because of the problems that I've seen arise from this concept, it's often better times to just say the parties will generally, parent, co-parent, and make the, share their parent time, make it available to the other parent if it makes sense. But again, it's more loosely adopted so that to avoid the confusion and conflict around this rule. Now, the next step would be if you are going to outline this right of first refusal provision in your decree, make sure that it is realistic. So if you live really close to your co-parent, then it makes sense. If you're going to be unavailable, then sure, the other parent can watch the kids. However, let's distinguish between you got to run to the store for milk or you're actually going to be away for 8 hours working or gone overnight. So a lot of times, the general rule of thumb, again, this varies by what the parties agree or what your attorney helps you come up with, but the general rule of thumb, if you're going to be gone from the children more than 4 hours, then that's a significant enough time that you're going to offer that parent time to the other parent because of that presumption that parental care is best. And what that means, if you do insert right of first refusal and outline it in this manner with 4 hours or more parental right, then that means that even if you're remarried and you have a new spouse, boyfriend or girlfriend, then generally if you're going to be gone for more than 4 hours, you have the duty to offer that to the parent. However, again, if you want to plan for that scenario and avoid confusion, the more specific you are around those parameters, the better. You can make an exception for if you're going to be gone from the children and there's no, new spouse or grandparent available to watch the children, then you will extend it to the other parent. So basically, it's just something that if you're going to incorporate it in your decree, you want to think about and make sure that it's something realistic and fair. Sometimes we've seen scenarios where one party fails to follow with the provision, the other party gets wind, and again, see, it creates conflict because the other party will pull the plug on them providing that option to the other parent, and then it just kind of undermines the co-parenting spirit of working together. So things to consider in the right of first refusal is make sure that you live close enough together that it makes sense to do it. Factor in a timeline that is realistic. Distinguish going to the store versus an overnight stretch. A lot of times when we incorporate right of first refusal, we'll definitely do it for the full day, 8 hours or an overnight situation, because then it does make much more sense. And also you want to also contemplate exceptions to the right of first refusal where grandparents or other significantly close family members may be a good fit to watch the children and benefit from that bonding time, similarly incurring no cost for childcare. So outline those parameters in your decree. Now, another specific point about right of first refusal that is outlined in the code is that the person choosing to exercise their right of first refusal, meaning the parent that says, yes, I want to watch the children while you're at work, they have the responsibility for transportation. So they will come and pick up the child and bring them back around the times that you're away for work or for whatever other reason you're needing this care, child care. Now, if you opt against right of first refusal, again, there's always the overarching premise of good co-parenting relation. If just common sense is always available. If you're going to be away for a stretch, make the children available to the other parent. Similarly, if you are exercising, you need a babysitter and you're going to have surrogate care, then in the Utah law also requires that both parents have the right to know who is watching their children. So always be respectful to the other parent. If you have a babysitter, or if the other parent has a babysitter, both you and them have the right to know the name, address, and telephone number of the person watching your children. Right of first refusal, we're talking about it today because it's actually come up more in the last couple of weeks with the different spring breaks and children being off schedule and each parent trying to exercise and maximize their time with the children, which is great. But again, make sure if you opt for right of first refusal that it's practical, makes sense in the time frame, and be specific as possible in your decree around what triggers it and how it's applied so that it doesn't actually create more conflict with your co-parent. I'm Jacqueline Robertson with JR Law Group. If you'd like to schedule a consultation to speak about your specific case, go to my website, JR Law Group, and schedule a consultation or give us a call. And as always, follow us on Instagram at JR Law Group.